All right, I think we're now recording for our last class here on April 24th. So let's jump in together. I'm going to scroll down to the bottom of our page here for our content today, and there's a PowerPoint. There's a link to a slide deck PowerPoint there. You're welcome to look at that on your screen, or I'll be sharing it here. And just for our last class today, I had kind of three topics. We wanted to talk a little bit about special education records and some of those legal requirements for maintaining certain special education records. That was actually kind of on our list for last class. We didn't quite make it there, so I wanted to pick up on that and talk a little bit about it today. And then the second topic is talking about the role of the parent in special education. And what I mean by that is, well, we know that active parental involvement is a positive, something we want, but I'm talking more about who serves as the legal parent voice in IEP discussions when we find our students in difficult situations, whether it be foster care or wards of the state, things like that. Probably some of you have dealt with that question before. On the surface, it seems like it wouldn't be complicated to figure that out, but sometimes it is. So I want to talk to you a little bit about just the guidance that we have out there on how to ensure that we have someone in the role of a parent supporting students when we do IEP development. And then the last topic is really kind of jumping back to big picture as we end our time together. I wanted to talk to you about the differences between IDEA that drives our IEPs, Section 504, so students that might have 504 plans, and also the Americans with Disabilities Act, all laws that impact services and supports and accommodations that we need to provide for individuals that have disabilities, but they're all different yet. And of course, we focus, well, you as special education teachers, most of you are, of course, focusing on IDEA, but I just thought it'd be good to kind of pull in a big picture perspective of those three areas, because you also have students that may not have an IEP but have a disability, and your school is potentially providing accommodations and supports them as well. So I want to talk a little bit about that. But let's start with records. And I'm just going to move my screen a little bit here. There we go. Okay. All right. I'll try not to spend tremendous amounts of time on records here, but it is a topic that's important, because there are times where, you know, we as special educators are held accountable for maintaining and being able to provide records about a student and maybe their situation. But you can see that what I have on the screen here, these are just a few screenshots with highlights, and it comes right from the Special Education Procedures document, the most current one we have. And so what is a special education record? You can see that definition at the very top there. It's information that's recorded in any way directly related to a student, maintained by the AA or school, and relates to the evaluation, identification, or placement of an eligible individual, or the provision of FAPE to an eligible individual. So you can see that's pretty big and broad, and so it sometimes does cause problems. We sometimes find ourselves trying to figure out what exactly do I need to maintain. We have questions about that. Couple things you want to keep in mind. I guess the first thing is this 5-year rule. Okay, so the question to how long do I keep all these records? And then we'll talk a little bit more about what the records are. But the general rule is that we see in the administrative rules of special education, they specify 5 years. But notice that's after special education services end. All right, so most of the time, that would be graduate. If a student is on an IEP for many years, most of the time that's graduation. But sometimes it's when students may exit their IEP due to goal attainment. And occasionally that happens, with young students. I mean, you may have for example, a speech-only student, and perhaps they're exited in third grade and have no more IEP needs. We'd start that 5-year clock then. But it's at the time of exit, we are supposed to maintain for 5 years. And the main reason is so that would be available for audit. And there's different reasons where someone may be looking for records after a student exits. Medicaid is one of them. And I know that that 5 years kind of ties into that, because potentially Medicaid could be looking for information 5 years after an exit. But that's our general rule that we follow. And so the next paragraph down here, a couple exclusions and inclusions. It mentions it does not include gen ed records. Okay, and those could be things like grades, district-wide assessments, discipline records, things like that. But it would include progress monitoring data that you're collecting, and it could have been during an intervention phase, or it could be the progress monitoring data that you are collecting to monitor goals. So that is considered part of the record. All right. So we get this picture of this big, broad set of information that comprises special education records. And what is excluded? Well, what is excluded is really very narrow. Okay. So what we call sole possession records actually are excluded from being considered special education records. But the definition of that is very narrow. Okay, those would be things that would be used as a personal memory aid. And so just, in other words, something that would not be accessible or revealed to any other person except a temporary substitute. So, when I think of a personal memory aid, that might be my personal notes. I worked as a school psychologist in the AA for many years, and occasionally I would be involved in counseling or conversations like that with students. And so if I was keeping a log of notes from a group session or an individual session, I might have considered that a personal memory aid if I never shared it with anybody else. If it was in a notebook or in an electronic file or something like that. But the guidance that you see here on screen here, it does narrow it though, and it makes it kind of tricky because in FERPA, does not apply to detailed or comprehensive notes that might reflect clinical records and things like that. So there are some, for example, Medicaid requires log notes, and some of those would fall into the area of, not considered sole possession. So I guess it sounds like I'm kind of talking around this, but almost everything that you might collect in regards to student, provision of special education to a student is going to, for lack of a better word, count as a special education record. And so we want to keep that in mind. Particularly, I mean, you can see that highlight in the middle of the screen there. Once you've shared a personally identifiable information on any kind of a record, and it has been revealed to others, it is for sure a record. And here's a did you know? I should have highlighted this, but the word email is there. Did you know that if you send an email and really a text, to a parent or a teacher, with information about scheduling an IEP meeting or information about the IEP, if that electronic document includes identifying information like the student's name and so forth, that is now a record. So just to give you an example of how this can be kind of tricky, couple times working with the district and with our AEA, we've had, a parental complaint or even something that was maybe heading towards a due process complaint. And the family might have a lawyer and they might say, I would like you to send me all of the student's special education records. Well, of course, we know that's going to include the seemingly obvious things like the IEPs and evaluation reports and things like that. But any email that has that student's name in it that has been sent and shared amongst educators, special educators, that is part of the record. So, for one or two cases that I'm thinking of that I've been involved with, we've had our tech person, search the email system and glean any email that had that student's name in it. So then that became part of the record. So it's just this idea that so much information is out there, particularly electronically, and we think of it as being private information, but something like an email about a student's IEP planning, that would be a part of the record. So of course we want to be aware of that, careful with that. We'd never want an email to say anything derogatory about a family or a student or something like that, because that's technically sitting out there in an electronic file cabinet. And if someone says, show me your records, there it sits. Okay. So, the slide you're looking at right now is talking about this idea of sole possession records and but that's very narrow. Let me pause for a second. I'm just curious, has anybody had any, has this issue come up for people before, where maybe a parent was saying, show me this, show me that, and you were wondering, is that a sole possession record or is that part of the file? Just curious if anybody has had any experiences with this being kind of a tricky area. Quiet out there. And that's okay. That's okay. If you've not had that experience, that's probably, in some ways, that's a good sign. That probably means maybe you haven't had any controversial kinds of situations where, a lawyer type is looking for everything you have on paper. But yeah, the things like emails do become part of the records. All right. Sorry, folks, I'm having a little, somehow I've managed to draw a red, somehow maybe I am drawing a red line across the screen, or is somebody else doing that to, I'm not sure what that is. Let's see, what have I done? I don't know. Okay, we'll move on. Sorry about those random red lines. Next slide here. Who can access special education records? This topic comes up a lot. So you have your records living in lots of different places, whether it be file cabinets. Most of our records these days, live in the web IEP system and electronic systems and things like that. But who can have access to this confidential information? Well, in the state procedures, there's lots of details and lots of caveats and things like that. But the short answer is, FERPA, the Federal Education Privacy Act, kind of guides this, and we're definitely supposed to keep those records secure. If it's a physical file cabinet, things like locking them or limiting access to them to the appropriate people. If it's electronic, that would be password protected types of systems. But this idea of legitimate educational interests. Okay, so that means, ultimately that an educator who is working with a child does have the ability or the right to see their special education records. And so sometimes sometimes I think people, even special educators, have kind of misinterpreted that and felt that, well, gee, the general ed teacher, they can't even look at that IEP. Well, maybe I can share the accommodations with them, but they shouldn't be looking at that IEP. That's not correct. If a general educator was actively working with that student in history or whatever class it would be, they would be able to access information from their special education records. But we're required as systems to just kind of keep control over those things, to keep them secure so that only the right people are seeing them. Okay, so that's a little bit about who can access. Okay, destruction of records is a topic that shows up in procedures. We have to deal with this in the AAA, and actually we're kind of currently working on maybe different ways we can do this in the future. But there is a form that some of you are used to using, and there's actually two forms, one for AA destruction of records and one for school districts destruction of records. And so maybe some of you who are secondary teachers are more likely to use this because you have kids graduating. But this is a form that parents and or of age students would sign when they exit special education. And it essentially says, you're signing this and we're telling you in 5 years, when we no longer need your records, we're going to destroy them. And we're not going to tell you again. So that is a form for really about the last 5 years has been used. And the reason for that is the law says that we have to inform families about when the records are going to be destroyed, how long we're going to keep them, when they'll be destroyed. And so that's a way of doing that. In the AEA, for many years, we would keep kind of dead files in a file cabinet when they were paper. Now they're more electronic. And when 5 years would come up, we would mail a letter out to the last known address of the student family and say, hey, we're going to destroy these records. We're informing you. That wasn't a perfect system by any means, because sometimes the students would have moved. The letters come back and so forth. So now we're kind of in advance. You're just finishing, you're exiting, you're graduating. Please sign this form saying that in 5 years we're going to destroy the records. Okay, so that second paragraph on the screen, making reasonable efforts to let people know, is part of the ruling there. And notice it says, the AAs are generally using that form. School districts can decide how and when they're going to use that, but there is a form available for you to use in your district as well. Because and I have known districts that have struggled with this, because one district a couple summers ago was asking me some questions, and it was along the lines of, our basement has rooms full of special education files dating back to the 70s. What should we do with them? And so my advice to them was, well, you can destroy them, except, aside from that permanent record, you can destroy them after 5 years, and it's way past that. But, you were supposed to do your best to inform families that you were going to destroy them. And so occasionally a district might, put something in the paper saying, hey, special education records from this date to this date are going to be destroyed. So it's the best effort we can to inform families when records are going to be destroyed. And that notification form has been a slightly better way to do that, because, families will sign at exit time, And then we're basically telling them, we're not going to ask you again. We're going to hold them for 5 years and then destroy them. Okay, let me pause again here. Just how about any, I know records isn't a very thrilling topic, but just from the tidbits that I've told you here, any thoughts or questions about that, or things you wondered about as far as the way to maintain special education records? Still pretty quiet out there.
I have one.
Yeah.
So I teach 6th grade, and I'm hanging on to the actual pieces of progress monitoring. And the student goes through middle school, and they go through high school. And so I need to then, so now we're up to 6 years plus 5. So 11 years, I'm going to hang on to these. And then I need to make sure that the document that says we could destroy the records is signed, and then I can get rid of them.
I mean, that document would be when the student is leaving special education, though.
Right. So I need to, but okay, I'm just assuming that it's at graduation then.
Yes, yes, absolutely.
For simplicity's sake.
Well, but then they sign that, and we're saying we can get rid of them, and we're not going to tell you again, but we're going to maintain them for 5 years in case of audit.
Right. So that's what. So I'm actually hanging on to them for 11 years. Is the deal? But before I get rid of them, do I have to make sure that that document exists somewhere?
Okay, I see what you're saying. So in other words, you personally are maybe keeping those in your file cabinet, and the student moves on. Is that right?
Correct. The actual pieces of progress monitoring.
Yeah, and that's where do you store all this stuff is part of the challenge. I will tell you, in the AA we struggle with that as well, because we have different evaluators, providers that have test protocols and things like that, and we are supposed to keep them over time. And just what you described happens as well. A student has moved to a different AA or a district, and we do our best. But yes, I think in a perfect world, special education records that you as a special education teacher have, I think in a perfect world, that would kind of move up with the student. And so the new special education teacher in the next building would maintain those. They may not want to maintain those, but probably the best way is for all that information to follow the student as a working file. And then that way, when they do get to the end of their schooling and it's time to graduate, the current teacher would have them, and they'd be in a better position to know when they can get rid of that. Is that muddy enough to be unclear? But yeah, it's a big.
Well, I guess the only thing that makes me uncomfortable with that situation is this. Due to a situation that we've had in the past, we were asked at different grade levels to prove what we had done with the student. And the student was, well past my grade now. And so if I just pass along everything I've done, I'm relying on someone else to keep track of the proof of what I've done. And that makes me slightly uncomfortable.
Yeah. I understand that, and I can several of our AA providers kind of have had those same feelings over time, because they tend to want to hold on to things, but then you get into that position of how do I know when I can get rid of this stuff, and it gets it gets pretty overwhelming. But I think ideally, I mean, if it's not a sole possession record, if it's just part of their special education record, it probably should move on to the new teacher, and then they're going to be in a better position to know when to destroy that. But you brought up the good question, you brought up what is a question with a lot of people. I mean, I heard you assuming that, hey, I have to maintain all these progress monitoring probes and things like that. People ask frequently, do I really? All those, reading probes and things like that, do I really have to keep all those? And people like me have actually asked that question to others, legal types in the DE and so forth. And it's difficult to get a crystal clear answer. The safe answer is yes. You're safer to maintain those things as part of the record, just like we keep test protocols. But a question we've had even as an AEA system is, we get that, but what if, all the information in my testing protocol I've now turned into scores, and I've put that in a report, and for sure we're going to maintain that evaluation report. Can't we then get rid of the protocols or the probes or things like that? And unfortunately, I tend to get fuzzy answers with questions like that. And so the safest position is, it's best to keep those things, even though it seems pretty laborious. It just is. And there might be a few of you out there that even, but there are a few of you out there, I know there are, that do alternate assessment, and like the early literacy alternate assessment, which involves collecting pieces of evidence in a portfolio. We have been directed by, the DE consultant has said, yes, you should maintain those portfolio evidence pieces, and that ends up being a good stack of paper. It truly does, unless it's stored electronically in a different way. So while it's pretty laborious and awkward, I think that's the best advice that I could offer, is that it should be maintained, and it probably makes more sense for those kind of what I'm using the term working file to move along to the next teacher. But I can relate to your discomfort. I can, because you kind of feel like, well, that's my that's my evidence. But on the other hand, like your web IEP, you've got all your progress monitoring data loaded right in there. That's all of your evidence of results for your student, and that just moves right with the student. So it's probably best for the paper side of that to move as well. Any other records questions? Special education records is probably in the top 10 fuzzy answer territories here. Okay. Well, how about the role of parent? It is the second topic that I wanted to just touch on today. Can get confusing. Who is in that role for students that have different kinds of disrupted family situations, if they're removed from their homes, if they're in foster care or shelter care, all those kinds of things. And there's a link in the PowerPoint here, and this is nothing terribly exciting. This is just simply this is kind of 6 pages that come right from the state procedures. I thought I would just link that in there, but I wanted to highlight a couple things. Well, we know, first off, we know that, an IEP team needs to include a parent. That's a required member of the team. But who is that when we have disrupted family situations? Let's take a quick look at some of the basics, and then there's more pages to get into real nitty-gritty caveat kind of situations. But if you look at what's on screen right now, who can act in the role of a parent? In general, a parent could be a biological or adoptive parent of a child. That's, of course, an obvious one. A guardian, an individual such as a grandparent, step-parent, or other relative with whom the child lives and is acting in the place of a biological or adoptive parent. A child who's legally responsible for the child's welfare. An extended educational decision maker, or a surrogate parent. Okay, so that's pretty broad. And it opens up a lot of things. It opens up, speaking of things that make you uncomfortable, sometimes this is one of those. So if you look at that definition that I just read through right there, what if you're a teacher of a high school age student, and that high school student gets angry and moves in with a family friend, and there's an adult that's kind of acting in the role of a parent. Could that person sit in the role of a parent in IEP staffing? The answer is yes. That's possible, and that's the type of thing that can really make people very uncomfortable, because you have that clause in there of someone who's acting in the place of a biological or adoptive parent. Other relative in the absence of the biological parent. I got a very clear answer. I had a student one time that was living with an aunt in one of our Green Hills districts, aunt and uncle, and there was no loss of parental rights, but the mother was not only out of town, but just in a different country, just kind of gone, and had been happily, I mean, it was just amicable, just left in the care of aunt and uncle, and we needed to evaluate that child and get a consent to evaluate the child. And when I talked to a legal consultant at the DE and said, can the aunt and uncle sign? It was no problem. Absolutely. That aunt and uncle, they're in the role of a parent, they can sign. Okay, so there is that kind of broad definition. I will usually advise people, though, if you might have these unusual situations, but if the biological parent is easily accessible and lives down the road, I think we're better off first of all, inviting them into the process, but inviting them to be the one to officially sign and things like that. So, but just be aware that this is a pretty broad definition. But who cannot be in the role of a parent? Foster parent. How do you like that? Foster parent cannot be in the role of a parent, even though they've been designated as a foster parent. A public or private agency involved in the education or care of the child. You see things like that. So they give examples of who may not serve in the role of a parent. And this is for IDEA. This is for special education planning. But the Department of Human Services or agencies contracted by DHS, group home directors that are in care of the child, caseworkers. Okay. And I'm not picking on DHS. I'm really not trying to. However, for years and years, sometimes we've had DHS caseworkers who will tell you the wrong thing, and they believe they can come to the IEP meeting and be in the role of the parent, but that's actually not correct. That's actually not correct because of that idea of a conflict of interest. But for foster parent, you can see the caveat there, but they may not, by virtue of their foster parent status, be deemed a person acting as a parent. However, they're not precluded from acting as a parent in circumstances that may allow. So they give a couple examples there. Foster parent may act as a parent if assigned as a surrogate, or they may act as a parent if the foster parent is an individual such as a grandparent, step-parent. So if grandma has been designated as foster parent, grandma can then act in the role of the parent, or if they're assigned as a surrogate. And that's something too. Maybe you've never had to do this, but if you're ever in a situation where you really don't think you can identify who is in the role of the parent, does this child have a parent that can sit in the IEP meeting? In those situations, we have to assign a surrogate parent, someone that can kind of advocate for that student, and that can kind of come through that does come through our director of special education, David Van Horn. He has to assign someone. The school may have someone in mind, and they can be assigned as a surrogate. So, all right. So this document, it fleshes it out more as it goes through. I'm certainly not going to sit here and read all this to you, but let me pause again here. Have you had any? Anybody want to share? Have you had a situation where you had this question? Who is it? Who should it be?
I have a question.
Yeah.
So yes, I had this same situation. The child was in foster care. The parent was completely unreachable
Mhm.
um, in rehab in a location where I could not speak to them.
Mhm.
And the people working with me told me they could act as a parent, and I had to actually print off this page and give it to them and say, no, you can't. Here, and here's the paperwork telling me this. So I do have a question then about this surrogate parent part.
Mhm.
Repeat that again as to how that would work, how
Yeah.
you get one of those.
Yes. Yes. So the
Ron,
AA.
can I interrupt?
Yes.
Because she's actually talking about the student that I had this year that you and I worked together on getting this kiddo a surrogate parent.
Okay. Okay.
Okay, so again, but the mom was now out of rehab. Um, Supposedly was living in a different town, but she had no permanent address. Called the AA in that permanent town. They had no permanent address. So we were running into a problem for her. So we were running into a problem. So that's when you and I connected. Then we sent out surrogate papers. David did to this
Mhm.
family. And then these two moms, who are the foster moms, became the surrogate parents for
Mhm.
this young man and then was able to sign off for him.
Yep.
So this is all through David Van Horn. Like
Yep.
the request goes
You
through him.
you cannot do it by yourself.
Yeah.
Gotcha.
There's a form. Of course, there's a form for everything, right? There's a form that just says requesting a surrogate parent, and so if what usually happens, often a school, they may have someone, hey, can this person be the surrogate? That goes to David, and he has to approve it, and so a letter just goes out saying this person is approved to be, and so the whole point is for someone to be identified that would not have a conflict of interest, that could sit in and advocate for that student. And so, yes, thank you for sharing that. And so that in this case, the foster parents, without that designation, they could not. I know, and it all starts to seem silly, but then once they were designated as surrogates, then we were good to go. So then those
Yeah.
foster parents could have signed consent if needed, and they could sit in the IEP meeting and serve in that role.
All right.
So
Thank you.
up in that first section, individuals who may act as a role of the parent. So who's an extended educational decision maker?
Yeah, that's
You?
no. There's a form for that too. So that would be a case of if a student needed help from someone who was not their parent to make good educational decisions. A person could be so designated. So in other words, if I'll try to come up with an example, and to be honest with you, it's not often used, but let's say a student had an intellectual disability, and maybe it was a high schooler, and rights had transferred to that student, and they might, the whole team might have felt like, or anyone might have felt like, we're not sure if that student is going to make good, solid educational decisions, and they need help. What if the parent had an intellectual disability? Someone could be designated as an extended educational decision maker to kind of help. So they're not taking the role of the parent, but they could for IDEA purposes.
But again, that's filling out the paperwork and they have to be appointed before anything can happen.
Yes, correct.
Yep.
Correct.
Okay.
Appointed by who?
For an educational decision maker, that would actually be that could be allowed by the parent. That could be allowed by the parent. So a parent in that case could appoint someone, or that could go through the AA as well. So in other words, it's for students who are stuck and don't have someone to advocate for them. These are options, and it's for, well, we're talking for IDEA. We're not talking about anybody who's going to be fully legally responsible for the student. It's for educational decision making and special education. Yeah, that one is honestly that's rarely used, but it is a possibility for a student who might not make good decisions. And here's the definition. An extended educational decision maker is a person who has the authority to make educational decisions for an eligible individual who has attained the age of majority and would ordinarily make these decisions by himself or herself, but has been determined to be unable to make the decisions. Okay, and then because it's not confusing enough already, I'll throw this in. The parent could be designated as the extended educational decision maker. So what if someone has a child with an intellectual disability that might make poor decisions once rights have transferred? The parent could be designated as an educational decision maker if they didn't have power of attorney, for example. So power of attorney is something else, much more powerful, where they're going to be completely responsible for the child. But what if you just need someone to help them with education? So what if you had a student with a intellectual disability, and they came of age and they just said, I'm not going to come to special education. I'm going to go to all regular classes. And what if they have a moderate or severe intellectual disability? Well, someone might need to help them with those decisions, and we can get someone to appointed to do that.
So what if you take this off the child and a parent comes in to the meeting drunk as a skunk or higher than a kite, and you don't feel that they can have a civilized conversation and make those decisions? Can you get this form and talk to them about what this form is and have them sign off for somebody to come into this meeting with them? Where do you draw the line there?
Yeah, well, see, the educational decision maker it's more about the ability of the student than the ability of the parent. You know what I mean?
Okay. Mm-hmm.
Yeah, I know we come across those situations where we say, "Gosh, this student can't get a break." The parents are really struggling, that kind of thing. That sounds more, if a parent, that almost sounds more like a neglect, situation if the parent is incapable, something like that. But the educational decision maker has more to do with the ability of the child who has come of age to make good decisions about their schooling.
Okay.
Okay. Any other thoughts or comments or questions or experiences maybe you've had with this one? It can, most of the time it's not an issue, but you do come across these situations where you have no idea who should be the right person in the room, and sometimes we have to go to these alternatives. So. Sorry, I'm having a little bit of trouble dragging my screen today for some reason. I'm trying to navigate here, and bear with me as I figure it out. There we go. Okay, I'd like to, let's see, let's see. I like to put you into breakout groups again, fairly brief, and then we'll just come back and kind of wrap up this last topic. But what I've got here is I just think this is a good frame, to help you think of the big picture of, how we assist our students that have disabilities in the school setting, because we've got IDEA, Section 504, and ADA that are all dealing with, individuals with disabilities. So what I like, and I just want you to kind of walk away with the kind of an overview of like how this fits for different students that might be in your buildings. So I want to put you in breakout groups, literally just for about, I think just about 5 minutes, but this is a kind of a one-page matrix that kind of compares them. I would just like you to have brief discussion, glance at this, and just have a discussion to clarify your own understanding, about these three areas and how they might work together to support students in schools, and also to see if you come up with any questions. So just about 5 minutes, I'm going to put you in small groups, look at this, try to come to a common understanding of how these three areas can assist kids in school, and then maybe come back with some wrap-up questions, and we'll go from there. So I'm going to do our groups here. I think we'll just do three. I think we'll do 3 rooms. So that'll put 3 or 4 in each room. And I will, I'm going to send you there, and I will see you back in about 5 minutes. And just a reminder, what would like you to, I'll leave it up on my screen here, but I forget if you still see that, but you have the link to this matrix that you can pull up on your screen and look at.
Ron, we were having a good discussion there.
And I cut you off, sorry.
That's okay.
All right, I think we're all back here. Well, so Julie says there was a good discussion going on in her group. Just you had a chance to look this over, and just kind of big picture. We know, of course, IDEA has to do with free, appropriate public education. It's what we do in schools. Whereas Section 504 is broader. And yes, it applies to schools, but also agencies or institutions that are receiving any kind of federal funding. And it's also about access and equality for individuals with disabilities. And the ADA kind of extends that coverage to employment and public and private institutions. And so, you kind of did some comparisons there. One thing that we notice, or we're quite aware of in education, is that IDEA comes with funding. Section 504 and the ADA do not, but yet there's requirements to comply with them. And you saw you saw some of the different kind of comparison points there. One thing, kind of scrolling down to the bottom, it's on the screen there. In IDEA, a real crux is the need for specially designed instruction. So there's this idea that you may, on a 504 plan, students with disabilities may be on a 504 plan, and they may need accommodations and different access issues, and that which might fall under 504 or at the ADA. They might need those things, but if they're not in need of specially designed instruction, they don't become eligible under IDEA. So that's kind of a big difference there as well. So how about thoughts from anybody? Just thoughts or questions that came up in your discussion groups?
Okay, ladies, we were having a great discussion. We had Amy and I weren't able to get on and see the document, so the other young lady read everything for us. The one question that we understand, for kids that are sometimes getting off of the IEP, they go on to the 504. We were wondering, is it as strict as it used to be of having a diagnosis, or was it a doctor's letter, or I remember we had to have, something from a doctor. Can you hear me, Ron?
Yes, yeah, you bet. Yeah. So for a 504 plan.
Ron, I know at the university level, we just take the request for accommodations or the post-secondary summary, and we take that into the office, the disability office, and that is all that is needed for documentation for a student who had been on an IEP when they are going, to post-secondary.
Yeah. So that's a good plug for that post-secondary summary form or the SAR form because that's a good point, Angie. If those are thorough and well written, that's kind of the goal, is that students could take that to their post-secondary destination, and it would hopefully have the information that's needed. So yeah, Julie, I mean, in general, like if you're talking about, going to a college or a school program, for 504 accommodations, yes, they would look for evidence of a disability. Notice it also talks about that, hey, so if let's say a college student had to, let's say that a university said, get an evaluation and prove to me. Maybe they might say that. I mean, the evaluation would be the responsibility of the student. Although some schools would offer it, they wouldn't have to. Whereas an IDEA, we do the evaluation for students, of course. So yeah, it's some evidence is needed, but we also know that 504 is very big and very broad. The definitions of disabilities, you see that they're a physical or mental impairment that substantially limits one or more major life activities. Huge, that can be so many different things. That can be severe allergies. That can be excessive weight. That can be just so many different things. Yeah, so some evidence of disability, but I think the answer, Julie, is that different schools and entity would interpret that a little bit differently because they left it so wide open. Yeah. And of course, we need to remember too that 504 plans may be appropriate for kids that are in K-12. If those students that don't need special instruction, a 504 may be what they need in school setting, and so chances are all of your schools have some 504 plans, and the school would need to have some evidence of the disability to write a plan as well. Yeah, and then of course, ADA, kind of gets more into just anti-discrimination for those with disabilities. It for sure follows into the workplace, and just all the things that we're just kind of accustomed to now. Handicapped accessible restrooms, all of these things are really requirements of the ADA, even building modifications. So just a very broad coverage of creating supports for those that have disabling conditions. Has anybody, thinking of IDEA versus 504, specifically in K-12 education, have any of you have your districts had any struggles in knowing like which kid belongs on a 504 and which belongs on an IEP? Has that come up as a struggle, or has that not been a problem? I think some districts maybe do struggle with that a little bit.
We've seen a lot more parent preference versus school preference.
Oh, so meaning parent prefers a 504?
Right.
And I'm curious then, so can you think of cases that, so if the parents said they prefer a 504, do you know why? Did they express
A
why?
lot of them were they were in special education themselves and had a negative experience
Mm-hmm.
or felt stigmatized, and so they wanted to avoid that if possible.
Mm-hmm.
But I think once you kind of build a relationship with the parent, they can make maybe a more clearer decision.
Got it. Yeah. The interesting thing about 504 and IDA as well is that, we know that you guys well know the paperwork requirements for special education have increased. We have very refined systems of record keeping, more pages than we wish, I think. It's not that way for 504
Mm-hmm.
plans. You're required to have a plan. There are some shells out there, but, for example, there's not like a mandated form for Iowa. And it is interesting that it evolved that way because in some ways, violating Section 504 is a bigger deal. If you violate Section 504 for a student, that's discrimination. That's the operating word, discrimination towards a disability. Whereas, in IDEA, it's not providing the appropriate education. So, in some ways, 504 has has a bigger stick, but yet it's not been, it's played out a little bit differently over time. I think part of that has to do, sadly, part of that I think maybe has to do with the fact of the funding, because we know that, you know, there is federal funding that supports special education, whereas it's not the case for 504. All right. Any other comments or questions about that comparison matrix? All right. Well, our time is about up here, and I want to thank everybody that's been a part of the class. I've enjoyed meeting with you in this virtual method, and everybody should get kind of the generic course survey, you know, through our PD system. Really encourage you to take a few minutes to fill that out. I honestly, and even add comments about your thoughts about the class. Angie and I would both be interested in, you know, feedback that you have on this class. It was a little bit of an experiment. You know, originally this sprang out of us saying, you know, we have IEP training annually. It's really geared towards new teachers who are brand new to the system. You know, should we be offering something that's for veteran special education teachers? And so it sprang out of that. And then, so I guess I'd be interested in your feedback, you know, number one, on how you thought the virtual format worked, you know, and you know, tell us the truth. I mean, was it a disaster? Was it great? You know, so how did it work doing a fully online class like this? And then also, as far as topics, you know, if we do something like this down the road in the coming year, this year we, you know, as you know, we kind of went topical. We tried to think of, you know, maybe tricky topics that you guys may come across as veteran teachers and dig into them a little bit more deeply. But maybe you can think of something else that you say, gee, I wish there was a class that covered this, you know, an area that you'd like to maybe appear in a class like this. So give us feedback. We'd like to hear it. And again, appreciate everybody being a part of it. And I'll be watching for more assignments to come in for those of you that are doing the credit. And Angie and I work on getting those grades and transcripts out as soon as we can. So,
Ron, I did have a question.
Yes.
How do you want us to get that assignment to you? Do you want us to fax it to you, drop it off?
Yeah.
Do you want copies of the IEPs?
No, and no, I'm glad you brought that up, Sandy. So don't
copies of the IEP.
Yeah, electronically is totally fine. So like you could write your reflection in the Google Doc or even an email. That's probably the easiest if you just email it to me. And don't worry about getting me a copy. I have access to the web IP system. So if your reflection says, hey, I'm talking about John Doe and Susie Doe, and I know you're in Atlantic, I'll be able to look those up, and that'll maybe save you mailing some paper. So yeah, as long as I have the student names and district, I can pull up the IEPs and just kind of read that along with your reflection.
Okay, so I can just email it to you.
Yes, that'd be perfect.
Okay, thank you.
You bet.
Ron,
Yes.
I had another question that came up today, kind of a chat between several SLPs regarding accommodations for testing such as the FAST. And I think we had 9 different answers to the question going. The question was, can we put in accommodations based on a student's speech or fluency impairment for tests that are given to everyone, such as the FAST?
Yes. No, I know that is and has been kind of a hot topic. So we know FAST it's a fluency, it's a reading test that involves fluency. So if you have a disability that directly impacts your fluency, is that a fair assessment or appropriate assessment, you know, of reading ability? The answer is, in a test like FAST, if, you know, what would the accommodation be? You know, if it would probably invalidate the construct of the test. I mean, the point of that test is to see, can you read fluently? But if you have a disability that's directly impacting that, you know, probably an accommodation would change the whole meaning of that test. So Hillary, what most, for students that have maybe severe fluency, language issues, I think what most districts are doing is that they're using, for those accountability purposes, there's that comprehension portion of the FAST, and they're using that for their benchmarking instead. Was that among any of the 6 different answers that you got or not?
No, actually that wasn't.
Okay.
One person had said they were taking the time constraints off, which then, as you said, would invalidate probably the scoring for that. Other people were saying they shouldn't be taking that test at all, but I don't know how a district would get around that. I mean, I think even for a student who stutters, they would want to know their reading fluency score. Others were being asked to write in accommodations based on speech impairments where the student is very unintelligible. And so maybe that is having an impact on what their score would be on any kind of reading orally.
Yeah, it's just, for the kind of kids that you're talking about, it would, it'd just be really hard to get meaningful information, out of that particular tool. So it, in most cases, people are, and I'll see, the name of the other probe is escaping me, but it's there's the different components of FAST. One of them is a brief measure of comprehension that yields a score. And I do know, districts are allowed to use that as their benchmarking item. And so I think for some of the kids that you're talking about, which would be pretty small population, I think that, I believe they're using an alternate measure. Okay. So. But you're telling me there's not everybody hears that, and you're hearing different things, and maybe that's something we should get some clarity out to just through. Yeah.
I think districts are asking SLPs to put in accommodations in the IEP to address participation in the FAST. And SLPs are not knowing if they should do accommodations or if they shouldn't.
Okay. All right. That's so maybe that sounds like maybe a good communication to the SLP group specifically. Yeah. Okay. Thanks for that heads up. I'll see if we can get something out on that. So.
Okay. Thanks.
You bet. All right. Thanks, everybody. Have a great day. It's pretty beautiful out there, I think. So take care.
Thank you.
You bet. Bye.